like to reserve 5 minutes, Your Honor, if that's possible. May it please the Court. My name is Chris Caston, and I represent Westbrook Isles Partners 1 LLC, which I will refer to as WBI or Westbrook Isles. This is an issue about whether or not the statute of limitations did or did not run. It concerns a summary judgment that was entered by Judge Day, and we believe that there definitely is a material issue of fact as to whether Westbrook Isles knew or should have known that the legal description that was included in the closing documents did not include the land. There's two concepts that impact this. The first is the delayed discovery context that's contained within the statute, which says that the statute of limitations runs when the cause of action is discovered or should have been discovered with the exercise of due diligence. Those are statutory provisions that are included within 95.11. The fraudulent concealment document, and that delayed discovery doctrine is also sometimes referred to as the blameless ignorant doctrine, on the theory that the plaintiff should do something at some point in time without any fraud or without any concealment to discover what is the cause of action that it may have against somebody else. The fraudulent concealment doctrine says that if there is fraudulent concealment of the facts that would cause somebody to not understand the cause of action against them or that they had a cause of action, it really is separate from the delayed discovery doctrine and really focuses on the defendant's wrongful conduct that occurred. In this particular instance, the wrongful conduct that occurred, which the record is clear on, are the representations that the Navaretta defendants made at the closing that everything was consistent and all right with the purchase and sale agreement, that everything was okay to sign, when it wasn't. What was in the purchase and sale agreement was the purchase of land. Navaretta knew that. He was advised that we want to purchase the land. But what was included in the closing...
What may have been a fraud at the closing is different from what is fraudulent concealment. Because then the question is, post-closing, what was done to prevent your clients from learning the truth? Am I looking at that right?
That's the way that the defendants would articulate the issue. And the doctrines are different, but the question really is, on that issue, is what impact does that fraudulent concealment have to the plaintiff's ability to understand what it got at the closing? At the closing, they went in there, they expected to buy land. They didn't know that that unit's description didn't include that land. Navaretta never told them. As a lawyer, they relied on their lawyer. As a closing agent, he had an obligation to include in the closing documents things that were consistent with the purchase and sale agreement, which was for land. That was not done. So
but all that was subsequently cured, wasn't it? Did they ever get the proper descriptions of what they bought having been condominiums as opposed to raw land?
Well, it really wasn't. I mean, the raw land concept is I'm not sure that they thought that the unit's description included the land. That was their problem.
No. My question, let's assume at the closing,
right,
there's a description that describes raw land.
Okay.
Subsequently, they get proper documentation that shows undeveloped condominiums. Is that factually how it went?
No, Your Honor. At the closing, they received the unit's description, the first improper unit's description, which was for units. So right at the closing, they got that unit's description. They thought that included the land.
But there's nothing that prevented them from reviewing those documents pre-closing. There's nothing that prevented them from reviewing those documents post-closing, correct?
They relied on their lawyer, Your Honor, that they knew.
Reliance on the lawyer is different than the lawyer undertaking an activity to conceal from his client what has happened.
I think the fraudulent concealment concept for the attorney is that he should have made this clear to them that they were not getting land in the transaction because they wanted to buy land. They told him that at the front end. They did not get that. He should have told them that when he was their lawyer prior to and at the closing. They had no reason to know that they weren't getting the land. They had no reason to investigate that they weren't getting the land.
I assume he had a duty up to the time of closing to describe what they were indeed purchasing.
Right.
And thereafter, my question is,
yes,
what
sir.
specific act, apart from not telling them, what specific act did he undertake that made it difficult or impossible for your client to determine that, hey, I really bought undeveloped condominiums?
I don't think there's any evidence in the record that he did any act post-closing. But the
well,
question...
Isn't that what's the heart of a fraudulent concealment claim?
The heart of the fraudulent concealment claim is what would the jury, how would the jury decide that that particular failure to advise at the closing impacted the plaintiff's ability to know when the cause of action occurred? It's what's the impact of the fraudulent concealment that occurred at the closing? I mean, what is that impact? I mean, if the unit's description were there, I mean, the plaintiff received trim notices that identified land at $6,000 and building at $0. They got no notice from that. They thought they had the land. They carried the land on their K-1s, or the property on their K-1s as real estate. They had a vacant land contract later after the closing that was for the sale of vacant land. They thoroughly thought they were buying land. So the question is, what's the impact of what he did at the closing? And that's why the fraudulent concealment doctrine says it's a question for the jury when there's a material issue of fact about fraudulent concealment. What is the extent that the tolling should affect the plaintiff in what happened here? How much should he have believed that this unit's description should have included the land? At what point in time should he have been put on notice that maybe I ought to go out and investigate that to decide whether we got the land or not? Those are issues for the jury.
Isn't that a duty that's incumbent on your client? As I understand the record, they chose not to read the descriptions.
They claim they did not get the descriptions at the closing, prior to the closing. They didn't have that. They claim they did not receive it, or they didn't read it. There was one...
And they were happy to go forward not having seen the documents.
Turn to their lawyer, and the lawyer should have told them. He should have said, look, this is a problem. You know, you're not going to get the land here. And he knew that. He'd been sued in malpractice on this specific issue of this particular turnover on this particular amendment to this particular condo deck. The seller testified they thought they were selling land, erroneously.
Aren't these experienced developers?
Not in condominium development. And that whole concept of...
Well, simply looking at this aerial...
Yes, sir?
I see an area of developed condominiums with one blank space.
Well, there should be 5 blank spaces in there.
Well, but your client intended to buy the vacant spaces that are surrounded by condominiums that are all architecturally compatible. They all look the same.
Right.
Does that not behoove an experienced developer to say, wait a second, I'm not going to own this land. This is within a condominium development. Let me look at the public records that go back to 1995 that say this is part of a condominium. They all have to be architecturally compatible. You're not going to be able to build whatever you want on this piece of land. So it's my understanding they wanted to build or develop these condominium units, and it was the market is what determined or what caused all of these problems.
They thought, their misunderstanding was that they thought that if they couldn't build condominiums, they could build something else on the property. That was the fundamental misunderstanding.
Let me go back to this then. What leads your clients to believe that they can build anything here other than an identical condominium?
They relied on the contract for purchase was in fact for land. It was.
But see, my question here is, why didn't someone ask, are we buying land?
And we believe that the lawyer had they told them that when Doug East went up there and said, here's the flyer for vacant land, we want to purchase vacant land, this is what I want you to buy, the contract was executed for the purchase of vacant land. Now, at that point in time, Navaretta should have told him, you can't get vacant land there. There is no vacant. This is subject to, all you can ever build are condominiums, and really what you're buying are unbuilt condominiums because the land's already been turned over to condominium ownership. You have the space in the air is all you're buying. You're not buying the ground.
Well, but the title commitment makes reference to a declaration of condominium.
Your Honor, my hearing is not too good. I didn't hear that.
The title commitment makes reference to a declaration of condominium.
It does.
That puts you on notice that it's subject to the reservations and of the condominium association, the restrictions and reservations of the declaration of condominium, doesn't it?
To me, Your Honor, these people relied on their lawyer, and the lawyer should have told them that, look, you can't do this. The condominium statutes define a unit as land or improvements, or improvements. It can be anything. You have to go to the condominium declarations that are recorded for this particular development, which is what you're referring to understand what that means and how it all fits together. And that's what they relied on their lawyer for. These people didn't, they relied on their lawyer for that understanding of what was in the condominium documents. And that's where Navaretta should have and had an affirmative duty to tell him. And he didn't do that.
So their cause of action, let's try to make it simple for you.
Yes, sir.
Their cause of action for legal malpractice accrued at the closing.
Except to the extent that it was fraudulently concealed. Yes.
Their cause of action accrued
for malpractice, yes, sir.
And the only way to get around the 2-year statute is to demonstrate that the lawyer undertook some affirmative action post-closing to prevent your client from discovering the real state of affairs. I
don't think so, Your Honor. Because at the closing, the fraudulent concealment occurred at the closing when he told them this. He did not.
Fraud occurred. The alleged fraud occurred at the closing. I'm having trouble
it's
distinguishing.
The same fraud. It's the
I'm having trouble with that.
Okay. The fraud, as I see it, the fraud that he perpetrated was not the concealed fraud. He had a duty as the fiduciary to tell them this.
But for statute of limitations purposes,
right?
To get the 2 years longer, he has to undertake something thereafter to prevent your client from being able to discover what had happened. And if it had gone to the public records, they would have seen all sorts of stuff as to what they really bought.
I don't know that I would agree with the court that what happens at that particular moment determines whether it was fraudulently concealed. The act of what he did at the closing did fraudulently conceal what happened. I mean, by not telling them, they didn't know. They intended to buy land. They meant to buy. They didn't get land. He should have told them. He didn't tell them then. He didn't tell them at any point in time. And they got the documents, and so they didn't know. And that's why they didn't know, is he didn't tell them.
Wouldn't they have known in 2006 during the mortgage with Mr. Calamaris, when the property within the mortgage and note was described as condominium units? 20 condominium units? Wouldn't they have been on notice then in 2006?
The question is, did they really understand what they had? And the answer is no. Did George Calamaris individually know that this didn't include the land? No. Should they have looked at those particular documents and determined what they did own if they didn't trust their lawyer? I mean, what they got at the initial closing were units. If that lawyer had told them that doesn't include the land, they would have known. Are they on notice of what the meaning of those corporate or those declarations are? That's why you hire a lawyer, to go out and explain it to you, to make sure you understand what's going on. He should have told them. I mean...
But I'm giving you the benefit of the doubt. I'm giving you 2 more years. In 2006, when they execute the mortgage, the property is described as 20 condominium units with phases within the mortgage document.
Right.
Because in 2006, you've discovered some type of fraud or concealment at that point, because you described in your mortgage something different than what you're saying that you bought.
Well, what they found out was different than, well, what was it? First of all, what was in the mortgage was the second legal description that was included in the second re-recording of the deed, where the Navaretta unstapled the first exhibit to the deed and stapled a new legal description because it was defective, and stapled a new legal description on it and re-recorded it. So the legal description in that mortgage comes from there was never a transfer of what was in that mortgage to my clients. My clients got what was in the first legal description, which is different than what's in the second legal description. So they would not issue the title commitment or the title policy on what was actually in the original title commitment with the original deed. After the transaction closed, they wouldn't issue a title policy. They issued a new title commitment that was unexecuted, that had a new legal description that was correct for the units, and then they unstapled it from the deed and stapled it and re-recorded it. When Keller says that whether or not the plaintiff has a duty to look at the underlying deed documents to determine if that deed has or contains what he intended to transfer is an issue of fact for the jury on whether the plaintiff should have known with the exercise of due diligence. I mean, in that particular case, the plaintiff transferred property. The title company was the closing agent, created the deeds, And in that deed was an additional piece of land that the plaintiff owned that was next to the piece that was being transferred. The deed included property that wasn't supposed to be transferred. They went to the closing, they signed the documents, they gave it to the, and they didn't figure it out until after the statute of limitations period is run. And the second DCA in that case said that statute of limitations says that the plaintiff, whether or not the plaintiff has a duty to inquire about whether his intent is included in the deed is an issue of fact. All of these are issues of fact for the jury.
Mr. Caston, I don't mean to interrupt you, but you're at 15 minutes.
Okay.
A little bit more than 15 minutes, but
let me take just one quick minute. The issue with regard, the two issues with regard to Commonwealth on the statute of limitations apply to the fiduciary duty in the constructive fraud case. Their particular duty in that case is a little different. We allege that they were a closing agent, and as a closing agent, they had a duty to ensure that the closing documents were consistent with the purchase and sale agreement. That did not happen. The purchase and sale agreement has phases, which is land. The closing documents had units, which is not the land. They were the unbuilt condominium units. They should have told him that was not included, that was improper. The breach of contract claim has nothing to do with fraudulent concealment or an extension of the statute of limitations. We believe that under the first title commitment, which went specifically to the property that was actually conveyed at the closing, which was the improper first legal description, the title company should have and is stopped, as we said in our reply, from denying the existence of a policy that's consistent with that original title commitment and the deed and the legal description that's included in that original title commitment. They never did issue a policy on that, but they still, under the law that we've cited in the brief, they had an obligation to insure that property. And what we're saying is that they breached that obligation to insure that property as they should have. We have a legal description that's not included in that title policy. It's got nothing, it's not in that title policy. That particular demand for payment under that policy occurred at its first point in January of 2011. On an insurance contract like this for title work, if you're making a claim for an uninsurable, unmarketable title, which is what we're doing in that case, we've cited that. That's in paragraph, I believe it's 184, where we say this is what the claim is. It includes for uninsurable and unmarketable title. And the damages that flow from that claim runs from the point that demand is made, not from way back when, as Commonwealth would say, when we claim that they breached the agreement by not issuing us a title policy. I mean, they didn't issue us a title policy. They still had an obligation to insure. They cannot walk away from that obligation to insure. We got that property at the closing. They violated that implied title policy by not paying when we made a demand in January of 2011. It does not involve any concept of fraudulent concealment. So if I have any time left, Your Honor, I will
give you 3 minutes.
Okay, very well. Thank you, Judge.
Thank you.
Good morning.
Good morning.
Scott Slater from Hillward Henderson on behalf of Mr. Navaretta and Navaretta, the firm. Just a housekeeping matter to start. Mr. Walson, who represents Commonwealth, and I have agreed to try to split the time about evenly, although he has blessed it if I use a few extra minutes depending on where we are. May it please the Court. Your Honors, I want to start by bringing us back to what is truly at issue and what the real claim in this case is, and it is very simple. WBI believed, they say, that they were buying 5 parcels of raw, unencumbered land. That's what they say they believe they bought. What they actually got was 20 unbuilt condominium units within buildings of phases of a condominium subject to a declaration of condominium. 5 parcels of unencumbered land, 20 condominium units. That's the claim. So the statute of limitations issue was, when did WBI know, or when reasonably should they have known, that what they got was not 5 parcels of raw land, but instead was something else, such as 20 condominium units. And on appeal, I did want to clarify this because Mr. Caston brought up the delayed discovery doctrine and some other things. The only issue that's being appealed is fraudulent concealment. That is the narrow issue on appeal. That is an affirmative defense to our affirmative defense of statute of limitations. And so Mr. Caston and WBI had the burden to prove that two elements of fraudulent concealment. Number one, that Mr. Navaretta used fraudulent means to conceal what the property was from WBI.
If they're right, certainly at the closing, there was something wrong with the documents.
Our position is there was nothing wrong with the documents, but for purposes of this appeal,
Yeah.
we can assume.
Let's assume there's
we're
something.
assuming that.
Okay.
We're assuming that.
Where does that take us on fraudulent concealment?
Well, and I want to address your point, Judge LaRose, about the active concealment or something after the closing, because you're right on point. The problem with Mr. Caston's argument is the only evidence he has to try and satisfy that first element is he refers to what happened at the closing. He says that Mr. Navaretta didn't tell them that this was 20 condominium units and that he said everything was okay. Putting aside whether that actually is fraud, we'll assume it for purposes of this appeal. The problem is that's the cause of action of fraud. That's not fraudulent concealment of the cause of action, which is the doctrine that applies as a defense to the statute of limitations. The case law says that what WBI had to prove was that Mr. Navaretta used fraudulent means to cover up and prevent, that's the language that the Florida Supreme Court uses, prevent the plaintiff from discovering the facts. And in this case, that would be discovering what the property was.
But under your rule, what you're saying is a client can never trust a lawyer. And then the client must very meticulously go back over to verify that what the lawyer said is true. And I'm not sure if that's a workable rule.
Well, with fraud, the way it works is there's a delayed discovery doctrine built in to it. So the statute doesn't start running until the point when the plaintiff knew or should have known of the fraud. That applies to fraud already. What we're talking about is fraudulent concealment. And so if that's all we were talking about, then we would look at knew or should have known, which we're going to get to, which they haven't satisfied that element either. But in terms of that first element, they have to show that Mr. Navaretta, after the closing, did something to prevent WBI from discovering the facts. And as you all saw on the record, it's the exact opposite. After the closing, Mr. Navaretta did what most real estate lawyers do. They send their client a closing package. It had the closing documents in it. It had the title policy in it. It had that re-recorded deed in it that Mr. Caston referred to. All of them referred to the property as 20 condominium units within buildings or phases of a condominium subject to a condominium. So not only did he not take steps to prevent WBI from learning it, he sent them the documents. He sent them papers that said what it was. But even if you want to assume that somehow they were to meet that element, you then have the second element. And the second element is that WBI had to show that they did not discover and reasonably could not have discovered what the property was that they bought. And the record and the evidence conclusively establishes that they did know what the property was, and here's why. Number one, as I mentioned, Navaretta actually sent them the documents that told them that it was 20 condominium units. And I do want to point out that although Mr. Caston now is trying to make an argument that hypothetically someone can look at the description, see 20 condominium units within buildings or phases of a condominium subject to a declaration of condominium and not recognize a problem or think it could be land or something else, that's not what his client says. We have, as we noted in our brief, we deposed Doug East, who was a WBI member and the real estate agent on this deal. He was engaged as the agent on this deal. And I put those descriptions in front of him, and I read to him 20 condominium units, et cetera, and his reaction was, that would have caused me concern. I would have been circling it in red. I would have wanted to talk to somebody and ask questions about it. Why? Because it says condominium units, and that's not what they wanted. That's not what they wanted. The record was very clear, and is very clear, that they wanted 5 parcels of raw land, not 20 of something, not condo units. They wanted land only. And so when Doug East was faced with that description, he said, yeah, that's a problem. And that should end the issue right there. But then you have the second thing. You have the tax bills. The government, starting in 2004 and year after year after year, was sending WBI notices that says, you have 20 condominium units within buildings of phases of a condominium. The government is telling them that year after year, and they didn't get 5 tax bills, they got 20. And WBI, in their testimony, has admitted that they not only received those bills, reviewed them, paid them, but WBI says that they wrote 20 checks each and every year and wrote in the memo line 20 different tax ID numbers. So even if you want to pretend that seeing the words condo unit within a building of a phase doesn't tell you that it's condo units, WBI knew that they had 20 pieces of property year after year after year every time they paid those tax bills. And again, the evidence is clear. They didn't want 20 of something. They wanted 5 of something. They wanted 5 parcels of raw land. And then finally, you have the evidence that open and shuts the case, and that is the 2006 mortgage and the subsequent foreclosure lawsuit. WBI itself entered into subsequent transactions involving this very property. So that required WBI and its managing member and their agents to sit down and figure out, what property do we own? What are we going to put up as collateral in this mortgage? And then in the foreclosure lawsuit, who are we going to sue? Who has an interest in this property? And so when WBI and its managing member and its agents sat down and picked up their own pen and wrote on paper what they had, they didn't write 5 parcels of unencumbered land. They wrote 20 condominium units within buildings of phases of a condominium. They referenced the declaration in their own writing. They referenced the amendments, which turned this particular property into condo units. They referenced the Florida condo statutes. They referenced condo assessments. And then they sued in the foreclosure lawsuit the condo association. Why? Because WBI put in their own writing why. Because the condo association would have an interest in this property because it's condo units and not land. And then most importantly, although it's hard to pick the most important part of those documents, WBI or its managing member admitted in writing, outside the limitations period, that it conducted a title search to determine who to sue, what description to use, what the restrictions were, etc. And it did that, and it wrote exactly what it was that they had, which is opposite of what they say they believed they had. So even if you want to disregard all of the previous events, which clearly told them what they had, those legal events, I'll call them, in 2006 and then subsequently in the foreclosure lawsuit, conclusively established that they knew what the property was, what the restrictions were, and what the legal description said because they wrote it in their own handwriting.
Mr. Slater, you're 10 minutes if you want to split your time.
I will conclude by saying this. If you boil down WBI's argument, what it is essentially saying is that the only way it would have knowledge or notice of what the property was if someone, probably even Mr. Navaretta himself, took WBI by the shoulders, stared it in the eyes and said, you have 20 condominium units. You do not have 5 pieces of land. And I say that because virtually every other type of notice there is happened to them. Navaretta sent them the documents that said you have 20 condo units. The government sent them documents that said you have condo units. And then when it came time for them to sit down and write themselves what they had, they wrote they had 20 condominium units subject to a declaration. And WBI's position is that's not enough. And I would respectfully submit that that is not the law. And if there ever were a case where summary judgment were appropriate, this is it. And with that, unless the panel has any questions for me, I will pass the baton to Mr. Walson.
Thank you, Mr. Slater. Mr. Lawson, you have about 9 minutes.
9 minutes? All right, thank you. May it please the court. My name is Jamie Walson from the law firm of Lowndes, Drosdick, Doster, Cantor, Reed in Orlando, here on behalf of Appellate, Commonwealth Land Title Insurance Company. Commonwealth was the title underwriter for purposes of this transaction. We understand that the appellant alleges we were the closing agent. We certainly dispute that, but understand that to be one of the allegations on this appeal. I'd like to focus on the two issues that are unique to Commonwealth in the appeal, the two identified errors. One, that appellant's action for breach of title insurance commitment is not barred by the statute of limitations. And two, that the trial court's denial of appellant's motion for summary judgment as to the interpretation of the agency agreement was incorrect. That's what appellant alleges. We believe the trial court appropriately ruled on both issues, and we'll start with the breach of the title commitment. In this case, what happened factually is on September 29th, 2004, a title commitment signed by Commonwealth's agent, Steve Navaretta, was faxed to WBI. They received it, had an opportunity to review it, and then on February 14th, 2005, following the closing of the transaction, a policy was issued pursuant to that commitment. The appellant argues that because of what I would say are minor discrepancies, Scrivener's errors in the legal description, that that policy is not what Commonwealth committed to issue. So the issue for purposes of statute of limitations is, when does the statute of limitations on the title insurance commitment, on the obligation to issue said policy, accrue? Logically, it happens when you receive document B, the policy, and you compare it to document A, and the two do not match. Now, the appellant has argued an estoppel theory in this case, but as noted in the briefs, it's not an equitable estoppel theory sufficient to toll the statute of limitations. We noted in the briefing that equitable estoppel would require some sort of representation by Commonwealth or Navaretta to toll that statute, and that didn't occur in this case. Instead, they say that we're simply stopped to deny our obligations. Well, in a case where we actually deliver the policy, and we say, this is the policy we are issuing you pursuant to the commitment, and you now say, well, we asked for apples and you gave us oranges, the date that accrues is on the date they received the policy, February 14th, 2005. There's nothing out there to bring it out any further. The second issue that the appellant alleges vis-a-vis Commonwealth, uniquely to Commonwealth, is the interpretation of an agency agreement. As with all title agents, there is a written agency agreement between Steve Navaretta and Commonwealth Land Title Insurance Company as to the scope and role of the agency itself. Appellant takes the position that that agency agreement makes Commonwealth a closing agent, not a title agent. And there's a Florida 4th DCA case, Summers versus Berman, which talks about the multiple hats that an agent can wear at a closing. They can be a title agent, they can be a closing agent, they can be a lawyer representing one of the parties, or a lender. But those are all distinct roles. And what's key is when you read the agency agreement, on its face, paragraph 1 says that the scope of the agency is limited to the issuance of policies, commitments, and collection of premiums. And as though that wasn't clear enough, paragraph 8 of the agency agreement provides, notwithstanding any provision hereof, agent's authority under this agreement is expressly limited to the issuance of policies and the collection of premiums as set forth above. So we believe the agency agreement is unambiguous on its face.
There's no theory under which that would make Mr. Kasten's client a third-party beneficiary?
There's no third-party beneficiary allegation in this case. That argument was never raised at the trial level. In fact, if I recall correctly, I believe we briefed the issue, but Mr. Kasten never argued it before the trial court. Even still, there's no intended third-party beneficiary theory that's been advanced, either in this appeal or at the trial level. And I don't believe it would be viable in any event. Even if WBI's interpretation of the agency agreement were given merit, which we don't believe it should, that would render the document ambiguous, susceptible to more than one reasonable interpretation. And at that point, one would have to look at the parole evidence that was heard at the summary judgment hearing. And there were two affidavits, one from Mr. Navaretta, one from Commonwealth, the only two parties to the agency agreement, and both uniformly said this is an agency agreement limited to title agency, not to closing agency. So for those reasons, we believe that Judge Day appropriately denied summary judgment as to the agency agreement and granted summary judgment as to the statute of limitations on the commitment theory. And the final point, which I'll make, just bouncing back to the commitment theory, is WBI would like you to believe that the statute of limitations runs from the date it made a claim on the policy. The claim made on the policy occurred on January 18th, 2011, and the language from that letter makes it clear that the claim is being made on the policy, not the commitment. It says, this letter constitutes a demand against Fidelity National Title Insurance Company as a successor in interest to the Commonwealth Land Title Insurance Company as regards to policy number A02-104-8154. That's a demand on the policy, not on the commitment. The commitment theory accrued as of February 14, 2005, when the policy was received, which facially was different from the commitment. And if the court has no further questions, we'll rely on our briefing.
Thank you very much. Mr. Caston, 3 minutes.
Thank you, Your Honor. Whether there was fraudulent concealment is an issue of fact for the jury. Whether or not the case that the Navaretta defendants and the Commonwealth cite, well, Navaretta defendants cite as being the demarcation point, that you look at the fraud that occurred at the closing and you separate that from whatever fraud continued after the closing. They cite Ray versus Cheminova. That's not what they cite a footnote in that case. There is no case law that I'm aware of that differentiates the fraud, the concealment fraud that occurred during the closing and at the closing versus what went on after the closing. The issue is, how does that fraud impact whether or not the plaintiff should have known about their rights with the exercise of due diligence? All this discussion about they had the units, they should have known the units. If they didn't know what those units were at the closing and they thought that included in the land, every time they saw the word units, they had a reasonable expectation that that might include the land. Now, that's wrong, but they might have had that reasonable expectation. So the impact of the fraud in not telling them by Navaretta that it didn't include the land would have continued. Those are issues for the jury to decide whether or not there was fraudulent concealment here. It's a jury call. It's always a jury call when there's a material issue of fact on fraudulent concealment. How long was the statute of limitations told? How long was the statute of limitations told? When should they have known in all of this? To respond to Judge Sleet's earlier questions about, well, they signed the mortgage. They certainly should have known in 2006. I mean, Keller versus Reed, 603 Southern 2nd, 717, which we've cited in a notice of supplemental filing, it says that that's true that people should be deemed to know what they sign, what it means when they sign, but not always. Not always. And in this case, the title company didn't tell them and did not extract from the deed the land that was there. They didn't know what they signed in that deed contained land that they never intended to transfer. They didn't know it. And the statute ran, and the court said that's an issue for the fact, or issue of fact for the jury to decide whether they should have known, whether they should have inquired about whether or not our intents in this deed that we're signing that you gave me are been complied with. That's an issue for the jury. It's an issue for the jury on fraudulent concealment. Whether there was and the effect of that after the closing going forward. When should that plaintiff have known that the statute of limitations ran? With regard to the contract, we believe that notwithstanding the scope and authority paragraph in the first paragraph, the contract says with Commonwealth, the agent shall. It doesn't give an option to the agent. This Navaretta was a closing agent. They signed the closing agreement, or the agreement with Commonwealth here. They were the closing agent on this transaction. And so the question to the trial court is, if they're instructed by the party to be the closing agent, are they the express closing agent on behalf of Commonwealth? It tracks exactly the language that's in the contract. And in this instance, they did do it. It says you shall conduct any closings of transactions. They don't have an option. They should conduct those. We looked at Navaretta and Navaretta as a closing agent on behalf of the title company. And we think, and for purposes of the issue that's raised to this court, we think that there is no ambiguity in this. Paragraph 8A, or 8 that was referenced also says, incur any it says title agent's only going to issue title policies, only going to issue title commitments and title policies. Incur any obligation or liability on behalf of the company other than as expressly set forth in the agreement. The agreement says they shall be the closing agent. We considered them to be the closing agent. We think that they were the express closing agent on behalf of Commonwealth by doing the closing.
Mr. Casting, you have to wrap it up.
Okay, thank you very much, Your Honor.
Thank you, sir. Thank you all. Our next case this morning is Gray versus Palm Beach Transport.